Good morning.
I'm Kathleen Griffin, representing Anthony Maxwell in this case. And we're asking that this court find that the decision of the Court of Appeals is in error. What this case essentially is about is whether an impermissible ex parte communication by a presiding judge in a criminal case to a deliberating jury can evade appellate review by hiding itself behind the contemporaneous objection rule. We believe the Court of Appeals' erroneous application of that rule is barring appellate review of the underlying issue, and we're asking that the Court find that this is inappropriate. The application of the contemporaneous objection rule by the Court of Appeals was incorrect. The crux of this matter is when Mr. Maxwell was notified of the judge's ex parte consideration in response to written jury questions. The facts here are extremely important because Mr. Maxwell, in looking at the record, Mr. Maxwell was never notified of anything. The only reason these things came to light at all is because his attorney at the close of business and before the judge recessed for the day thought to think, were there any questions? And in fact, looking at the record on page 399, her statement was essentially, there may have been a jury question. And her expectation truly was, no, there wasn't. But that was not the answer. The answer was, yes, there were two questions. And what were those questions? She asked, properly asked, what were those questions? And the judge responded, I can't remember, go look for them. I'm pretty sure it was something about jury questions. And the bailiff was sent scurried. And the bailiff scurried from the courtroom to the jury room, rummaged through the trash, went running after the jury foreman to try to retrieve the questions, and they were not found that day. But the judge gave her a remedy. The judge said, I'll address it at sentencing. And he said he'd address it at sentencing on two separate occasions. He basically said that questions weren't available, and if the court looks at 401 and 402 of the record, you'll see that the trial judge said, I'll address this at sentencing. And so in reliance on that, Mr. Maxwell's counsel prepared a motion to dismiss or vacate the sentence based on that issue and other issues that were not before this court. And the court made a ruling, and in the course of that ruling, in the course of that argument, Mr. Maxwell's opposition, the Commonwealth attorney, made certain statements. Those statements in argument were essentially that we knew when Mr. Maxwell's jury was in the box that these questions existed. And if that were the case, they should have been raised then. We suggest to the court that the language use, the use of the subjunctive mood of the verb, is exactly what the subjunctive mood is meant to be, which is to show what the Commonwealth wished the evidence had been. If they were there, then we would have done that. Absolutely correctly. If we had known, we could have raised it then. But the issue is, were we known? Was the court correct? Was the Court of Appeals correct in taking that language as an answer in argument in response to our motion to vacate, taking that statement out of context and say that's a proffered fact because we did not object to it? When a person uses a subjunctive mood, the Court of Appeals apparently believes that we have a duty to jump up and say, no, we object.
May I ask
yes.
a question? You are focusing on the Court of Appeals reference to the statement by the Commonwealth attorney. But in your memorandum in support of motion to set aside conviction, I find the language not quite clear to me as to when defense counsel knew. On the 63 of the appendix at the bottom, prior to the court adjourning for the day, it was brought to defense counsel's attention that there may have been a question from the jury. After the jury panel was dismissed, defense counsel inquired of the court if there was a jury question. So that almost seems to support the Commonwealth's argument that before the jury was dismissed, the knowledge that a question had been asked was made known to both parties. Am I reading that too literally?
Your Honor, I would suggest that is an incorrect reading, and in fact, the statement that was made by the Commonwealth in their subjunctive mood wasn't part of an argument. And the judge himself, the trial judge himself, said on page 437 of the record that counsel's argument is not evidence. We suggest if counsel's argument is not evidence, then what is alleged to be a proper fact, which we dispute, we say it's not a proper fact, is not evidence either and should not be taken to be construed as a statement of fact as to when people knew. The elephant in the room, Your Honor, is when did appellant's counsel, when did Ms. Maxwell's counsel find out jury questions may have existed? And the answer is the record doesn't say. But the question, and the bigger question I think for the court is, when it was brought to the court's attention, the court had an opportunity, and the law provides, and the reason that the contemporaneous objection rule exists, provides for the judge to fashion a remedy he deems appropriate, to deal with that issue. And what was his remedy? He said to counsel, I will deal with this at sentencing. They could not find the question. A second time he said, I'll deal with this at sentencing. Again, Your Honor, if... Let
me ask you a question, counsel. Let's say that we agree with you, and under 8.01-384, counsel is prohibited from making a contemporaneous objection. And we send the case back to the Court of Appeals. It seems like you want us to send it back to have them resolve the issue about what has to happen if the court erred by doing this outside the presence of the defendant and his counsel. And they could find it would be harmless error, couldn't they?
I would suggest if they did, we'd be right back here again, Your
Why?
Honor, because we believe that's not true.
I know, but that is a remedy that they could believe was appropriate, that it was harmless error. Because the answer, you're not really arguing that the answer was incorrect. You're arguing that the harm was that the client and the defendant weren't present.
Right now we're arguing that we're barred by the contemporaneous objection rule to even address the merits of the petition, the underlying petition. The merits were denied because the Court of Appeals elected to find it was barred by the contemporaneous objection rule, setting in play a stone, putting a stone in front of the merits. How could the Court of Appeals...
So if we agree with you and send it back and say it's not barred by the contemporaneous objection rule, then the Court of Appeals is going to resolve that issue about whether there are any merits to your argument.
That would be correct. Or in the alternative, this Court could simply say it's egregious and applying the ends of justice under 525, say this is egregious, this is so bad.
Why would we do that?
We didn't grant your... we did not grant your ends of justice assignment of error.
I'm sorry, I'll then withdraw that. Yes,
okay.
sir.
So what we do is send it back to the Court of Appeals and ask them to resolve the issue about whether the verdict should be set aside based upon this alleged error.
Yeah, that would be a remedy for this Court to do. And in fact, we would suggest that would at least give the Court of Appeals an opportunity to correct what we believe is a mistaken interpretation of that. This is a de novo review. The Court has the authority to review these issues of law, 8.01.384, and as well as 5A18 in this case, or 5...
And give some guidance as to what 801.384 means.
Yes, we could do that. Yes, Your Honor, we would. And we would suggest that it was the acts of the judge and the omissions of the judge that gave rise to the impossibility of the appellant to be able to address these in a more contemporaneous way.
And may I ask a question on the timing? Is the allegation that when the court sent the questions back into the courtroom with defense counsel absent, was that when it precluded her from making a contemporaneous objection? Or are you solely focusing on when she found out, whenever that was?
Your Honor, I would suggest it's impossible to make an objection to that which is unknown. And in this case, the only time that the questions became known is when the trial judge acknowledged their existence. Okay. And I would suggest to the Court, in looking at the Commonwealth's response, and in fact looking at the judge's response in dealing with these issues on 399 and 401, the judge essentially says, I did not bring counsel back, I didn't bring anyone back because I thought this was diminishment. I didn't think this was important enough because of the nature of the questions. That would tend to indicate, I would suggest, that the nature of the questions meant that the Commonwealth wasn't called back either. And what's most appalling about this is poor Mr. Maxwell was in the lockup at the jail and had been since August of 2011. He was he was closer than the jury. He was sitting not from here to the end of that room.
Let me ask you something. What difference do you think it would have made if they had brought him in?
Then he could have said, I demand my attorney, which is what Mr. Maxwell indeed
did. Right, but what if in this particular instance Mr. Maxwell was there, his lawyer was there, the Commonwealth was there, and they had a question, the court says, well, I'm just going to tell them that look at the instructions.
Yeah, and I would ask the court take a look at those cases in which jury instructions became an issue, specifically looking at...
But it didn't in this instance.
I'm sorry, sir?
It didn't in this instance. And it did not in this instance.
It did not what, sir?
You said, let's take a look at the cases where the jury instructions became an issue. They did not become an issue in this case.
No, Your Honor. But what I'm saying is, in dealing with jury issues, jury questions, in Mason v. Commonwealth in 1988 is a case in which jury questions, the counsel were there. And the counsel were all listening to what the judge said, giving proper instructions. But then when the jury went out, they came immediately back at the judge's request and said, forget what I said about those malicious wounding instructions. If you're having a problem with it, just take out these words. At that case, defense counsel was physically sitting in the courtroom. At that case, everyone was there, and defense counsel was mute, did not say anything in objection. And in that particular case, the Court of Appeals found that it was so surprising that this sort of thing would have happened that it was forgiven under 801-384. And I would suggest based on all...
Presumably, your absence from the courtroom is what makes the issue of whether a jury instruction is at play in the case an open question. We don't know. And it's the Commonwealth's burden in a constitutional harmless error case. It's the Commonwealth's burden beyond a reasonable doubt to demonstrate that the error did not contribute to the conviction.
Right.
So what, I mean, the question of whether you were there and what would have happened, it seems to me that if you're not there, we don't know what would have happened, because you might have had a different suggestion to the court.
Exactly.
And it might have put a jury instruction into question.
Exactly.
But we don't know any of
Well,
that.
and I'm asking you, what would you have done differently if you were there?
Your Honor, on dealing with that issue specifically, we could have asked to formulate a separate jury instruction.
About what?
To reaffirm the beyond a reasonable doubt defendant's presumption of innocence. Clearly, at the time they asked, and there were two questions they asked, one about Mr. Maxwell's face, which went to the issue of whether or not he was in a self-defensive posture, and the second issue had to do with the difference between malice, whether malice for intentional and unlawful wounding. In dealing with the issue of asking for Mr. Maxwell's face, they're apparently asking for additional information, and while they could not be given additional information because the evidence was closed, they certainly could have given a reiterative instruction regarding the presumption of innocence, for example. Would it have been helpful? Would it have been allowed by this judge? I can't tell you. Did we have the opportunity to do it? Absolutely not. And that's where we have the problem in this case.
Was there a jury poll?
Yes, there was, and the jury was unanimous. Thank you for taking the rest for rebuttal.
Good morning, Your Honors. May it please the Court, my name is Elizabeth Kiernan, and I represent the Commonwealth in this appeal. The Court of Appeals did not err in applying Rule 518 to preclude consideration of the merits of this case because the defendant's objection at trial was not timely made, and the savings provisions of 801-384 do not operate to excuse the defendant's default in this case. The record in this case does demonstrate that the parties were told of the trial court's actions in addressing the jury while the jury was still deliberating during the guilt phase. In other words, the defendant knew that the trial court had addressed the jury in his absence before the jury brought back a verdict.
What do you base that upon? I'm
basing that on the prosecutor's unilateral avowal, which was unrebutted by opposing counsel.
Unilateral what?
The unilateral avowal of counsel. The prosecutor made a factual proffer regarding when the parties were made aware of the trial court's actions. He's an officer of the court, and he made that statement as a factual statement to the trial court. The trial court then gave the opposing party an opportunity for a rebuttal argument, and the defense attorney acknowledged that the contemporaneous objection argument was a key point of the Commonwealth's argument. But then she did not go on to say that his factual premise was incorrect. The Commonwealth's factual premise stands. It is the only evidence in this record as to when the parties were made aware of the trial court's actions. There is no evidence in the record to support another interpretation of that evidence.
Counsel, let me ask you a question. I think the defense argument is the error was that she wasn't there, the lawyer wasn't there, and the defendant wasn't there. How can that be cured by any objection that's made after the events have already transpired?
Had the defendant raised an objection to the trial court before the jury came back with its verdict, the trial court could have asked that the jury be re-instructed and the defendant...
But that wasn't the claim of error. The claim of error was that I wasn't there in a critical stage of the trial when a question was posed. You can't go back in a time machine, I don't think, and put them back to the time when they did it, can you?
No, Your Honor. The defendant in this case, as you say, wasn't present when the trial court acted. However, counsel had an opportunity thereafter to raise the matter at a time where corrective action could have been taken. Corrective action is the touchstone of the contemporaneous objection rule. The trial court has to be in a position to intelligently consider the issue and take corrective action. In Reed v. Baumgartner, this court found that a defense counsel's argument for a corrective instruction or for a motion to mistrial was properly raised while the jury was deliberating when he had been prevented from making that same argument during closing arguments. I think in that case, the opposing party made an improper closing argument. He just said, I object.
So the focus of your argument seems to be really on what was said to the jury, what the judge did. That seems to be what you're focusing on. That they could have corrected if they made an error in what he told the jury. And now we answer the question.
The defendant's presence, the gravamen of the defendant's argument on appeal and throughout this process has been that he wasn't present,
right,
regardless of the content of
so
the
how can that be
corrected?
By an instruction, by a supplemental instruction?
The trial court could have re-instructed the jury in the defendant's presence. The trial court could have brought the defendant back out. They could have asked the same questions and answers again. And at that time, the defense counsel would have been able to argue for any of these additional instructions they claimed they would have argued for, which were not proffered. So if we came to that, that wouldn't be preserved for appeal in this case. They could have offered a cautionary instruction. They could have taken any number of corrective actions. But the fact is they prevented the trial court from being in a position to even try to correct these actions. The defendant's subjective assessment that there was no remedial action to be taken does not relieve him of the burden of objecting. This court has held on multiple occasions that the perceived futility of an objection doesn't relieve you of the burden of objecting. And that's exactly what happened here. The defendant stated she thought there was nothing that could have been done, so she didn't object. That's not her burden. She had to make the trial court aware of her argument and that she was seeking remedial action.
But I guess in this particular instance, she did make the objection. You're just saying it was untimely, right?
Correct, Your Honor. The defendant's objection, in order to have been timely in this case, as I mentioned, has to come at a time when the trial court is in a position to take corrective action.
And when was that? When was that, based on the record we have right now?
When the defendant should have timely objected or when the objection was ultimately raised?
No, when a timely objection been made here?
The defendant's first opportunity to timely object would have been when she found out that the trial court had addressed jury questions in the defendant's absence.
We know that couldn't have happened until she was called back to the courthouse, having been advised that the jury had reached a verdict.
Yes, Your Honor, and the record shows that there were between 15 and 30 minutes where the defense counsel was present in the courtroom while the jury was still in deliberations.
Where does that...
But they had notified the court that they had reached a verdict, correct?
Your Honor, the record demonstrates that...
That's why they called them back. That's why they called counsel back. The jury has reached a verdict.
Your Honor, I don't believe that the record is clear on that point. The record... In the defendant's motion to set aside the trial, she states that she came back to the courtroom at about 5 o'clock. The jury was not called back into the courtroom until 5:15. There was 15 minutes in the interval there where the trial counsel could have raised this objection to the trial court.
Well, but here's my point. If they had already reached a verdict, how are you going to undo that?
Your Honor, I don't believe the record is clear that defense counsel found out after someone told her that the jury had already reached a verdict. Those facts simply aren't in evidence in this case. We don't know when she was told.
That doesn't help you because the burden's on the Commonwealth, not on the defendant, to demonstrate that the error was harmless.
Well, respectfully, Your Honor, in this case, the burden is also on the defendant to have a record from which this court can decide her case. And we're saying the objection
we can't get a record from inside a confidential jury room. Who's going to get that record?
Your Honor, the record would be of when the defense counsel was made aware of the trial court's actions, because we need to first decide whether this issue has even been preserved. And when the Commonwealth puts her on notice from day one that we're going to be arguing this is not a contemporaneous objection, and she does not respond, she puts no facts into the record. If this court is feeling there's a factual dearth here, it's the appellant's burden to provide this court with those facts to make out a claim on appeal.
The facts that nobody can know?
Your Honor, the defense counsel clearly knows when she was notified. It's not in our record here.
Do you know?
I do not know.
Do you know when the jury reached a verdict?
I do not know.
Well, then
it's
how
not
is she
in our
supposed to
record.
know?
Because the defense was present, Your Honor. I was not.
Well, no, let me rephrase that. Does the Commonwealth, in any person, the Commonwealth attorney, anybody know when the jury reached a verdict?
Well, I guess they would only know, Your Honor. I would concede that they would know because the court told them. But I don't believe this record says when they were told that the court told them.
So to follow up on Justice Millett's line of questioning, how do you get this scrambled egg back into the shell if there has been a contact by the jury with the court, an improper contact with the jury by the court, and they've gone back in the jury room and they have reached a verdict? How do you put them back to status quo?
Your Honor, they haven't given a verdict in this case until significantly
but they have
afterwards.
actually engaged in deliberations after an error. There's no question in my mind this is an error, by the way.
Yes, Your Honor.
And it's a pretty egregious error in my judgment. This goes right to the fundamental aspect of the sanctity of a jury and the rights of a defendant. So it's a pretty significant error. So the Commonwealth would have a burden beyond a reasonable doubt, because it's constitutional error, to demonstrate that it had no effect. I don't know how the Commonwealth will ever be able to demonstrate it had no effect, because we don't know when they reached a verdict.
Your Honor, to get to the harmless error argument, the trial judge's response in this case were referring the jury back to its instructions, which were argued by defense counsel, and it was a refusal to provide the jury with facts that were not in evidence. Those are patently legally correct responses. They don't add any new factual or legal information to the jury's deliberations. If we are to assume that juries follow the directions of the trial court, there is no way those instructions could have possibly impacted the verdict in this case.
You see, I'm not sure that I know, sitting here, the significance of that to defense counsel who was sitting there. I don't know what defense counsel would have suggested to the court. Judge, I think that question is a result of witness number 2 and the cross-examination. I think that was a result of the photograph that came in. I think that was a result of fill in the blank. I can't say that, but defense counsel could, but defense counsel wasn't there.
Well, Your Honor, had defense counsel raised this issue to the trial court before a verdict came back, we could have had this discussion. Had trial counsel raised this issue to the trial court before a verdict was in hand, this discussion that you're having now could have happened. But because no objection was raised, there was no discussion about what curative actions could have been taken. There was no discussion because the defendant decided to see what the verdict was going to be before they've objected. And this court has held in Crockett v. Commonwealth and in mistrial cases that you can't simply wait on the verdict and then raise your objection later if the verdict's not favorable to you. The defendant, even if it was only to make a record, as you say, still had to object in this case before the jury came back with that verdict, before the verdict was read in open court.
I understand your argument.
Can I point something out to you? I was just looking at the record on page 396. According to this, the court instructed the jury, and the jury left the courtroom at 5:28. The court was told, the court says, later the court says, I understand the jury has a verdict, and the jury returned to the jury room at 5:50. So we're talking about 22 minutes that the jury was out. So, but yet you seem to think that a lot happened in that 22 minutes. You see him?
Yes, Your Honor.
So we're talking about 22 minutes that the jury was out. And during that time, we know counsel left to get something to eat.
Yes, Your Honor, but during that time, we also know that the counsel was made aware that the trial court addressed the jury in her client's absence. Whenever that was, in that brief time period, the trial counsel had the obligation under the contemporaneous objection rule and Rule 518 of this court to bring that matter to the trial court's attention. She was sitting in the courtroom before the jury came back. She could have said, "Excuse me, Your Honor, I have a question I need to ask the court." Same question which she later posed when the jury had left the building altogether and no remedial action was possible. It would have taken but a moment to have said to the trial court the same thing she eventually said later. Even if that window was a short window, it was a window, and it was possible for her to bring this matter up at that time.
Right, and you're actually relying on the fact that the Commonwealth submitted that everybody was notified about it while the jury was still deliberating. That's
Yes,
what
Your
the
Honor.
avowal said.
Yes, Your Honor, and I will agree with my opposing counsel that this is a very fact-specific issue in this regard. That window is the only time when the defendant in this case could have raised a timely objection because they weren't physically present to do so earlier.
I don't want to speak for Justice Millett, but I'll tag on to it. I think what he's asking, and I know what I'm asking, is how do you cure an uncurable circumstance? And if it is uncurable because the jury went back there and continued to deliberate and perhaps even reached a verdict, if it's uncurable, what difference does it make whether her objection was before or after they left?
If, in fact, it was uncurable, Your Honor, the remedy would have been a mistrial, and that's something that the parties would have brought up with the court at that time. They're not permitted to hold that objection in reserve until the verdict comes back and it's not favorable to them. If there was, in fact, no objection, the mistrial needs to also be made in a timely manner, and that manner would be before the verdict comes back in this case. Again, as this court held in Crockett, the defendant simply cannot...
Counsel, if it was an uncurable error, then what does it matter that exactly when the objection was made?
Your Honor,
the reason you have to make a contemporaneous objection is so that the court can cure its error before the trial ends. But the premise of that question was this error may be incurable. And so why would 8.01384 bar an error of constitutional dimension if the court would not have been able to cure it under any circumstances?
Your Honor, in this case, the error, I believe, was curable. The error complained of is that the defendant wasn't physically present when the jury was addressed. And to get into the merits, we argued in the Court of Appeals there's a Jones case. It's 27 Virginia 425, citing Staples versus Commonwealth, 140 Virginia 583, where the defendant wasn't present when the ultimate verdict was read. And in that case, this court remanded it to the trial court to have the verdict read in the defendant's presence. The defendant's failure to be present could have been cured by simply reiterating what happened with him present in the courtroom. So I don't think this is a case where there was no possible error. And even if there were, it's not the defendant's position, or the defendant's not in a position to make that decision for the court and for the opposing party who could have suggested alternate action.
Can I ask one question, Chief? Where exactly in the record is this avowal that you're talking about? Can you give me a specific site?
Yes, Your Honor. I believe it's appendix page 431.
430, yeah, 431, the middle of 431.
Okay, thank you. No place else, though, right? I mean, is that it?
That is it, Your Honor.
Okay.
Okay, thank you. Mr. Butler?
We're being redirected back to the proffered fact by the Commonwealth as the only evidence. The alleged proffered fact the Commonwealth made that statement. If this were the case, then we could have done that. Again, the subjunctive mood proffered statement was part of an argument in response to our motion to vacate, to set aside, to give the court an opportunity to stop this from going to the Court of Appeals, to give him the new trial that he deserved. Because his remedy, and the judge had the remedy at the time that we brought this to his attention.
Let me ask you a question about the facts, based on what Justice Goodwin pointed out, that there was 22 minutes, do you believe that's correct? There was 22 minutes from when the jury was first given the case and when they came back with a verdict?
Yes.
So in that 22 minutes, defense counsel went back to her office.
Correct.
To get something to eat, whether she got to eat or not. The jury submitted 2 questions. The judge answered those questions. He sent the questions back to the jury. Then defense counsel in the Commonwealth learned of this and had a chance to be in court to make an objection, and then the jury came in.
No, sir.
I mean, is that what the timeline is supposed to be?
No, that's what it should have been.
I mean, is that what the Commonwealth saying in the timeline?
That's what they're suggesting, and I would
Okay.
suggest that the court...
So a lot happened in 22 minutes, isn't it?
Well, I would suggest that a lot didn't happen in 22 minutes. Looking specifically at 396, where we're dealing with the issue, jury left the courtroom at 5:28. Then the next day of a recess, then the court said, "Counsel, I understand the jury has a verdict. The only statement before the verdict is rendered, Mr. Robbins, the Commonwealth attorney, said, 'Yes, thank you, Judge.'" That's it. And in fact, in dealing specifically with the argument the Commonwealth raises, I would suggest to the court that the fact that the judge himself, in the context of the motion to set aside the verdict, the fact that he said, "Counsel's argument is not evidence," specifically stating that it's not evidence. What he wishes the evidence would be, using the subjunctive rule, this is not an inartful speech. This is not inartful use of language. This is, he said what he meant. He wished he knew. We wish he knew too. But we didn't, he didn't.
Counsel, let me ask you this. The Commonwealth made a point, irregardless of whether you could unring the spell, that if the fact that your client wasn't there when the questions were presented to the judge, so that you could say, "Judge, no, I want you to answer it a different kind of way," obviously, that you can't undo that, but that you could at least have asked for the mistrial before the verdict came in.
Before the verdict?
Well, yes, because that way, you're not waiting to see if the verdict's favorable or not favorable, whether you decide if you want a mistrial or not. Why wasn't it incumbent upon you, I don't mean personally, but the defendant, to establish a record for the point of view that would indeed show that counsel did not know about the questions until the verdict had been rendered, so that you could not even have made the motion for mistrial before the verdict came in? To me, that may be the critical question here, is not whether you could go back and re-instruct them and cure that, but whether the record demonstrates that you had no opportunity to move for mistrial before the verdict came in.
Well, I would suggest that the fact the verdict came in and then the jury was polled, then subsequently, after all was said and done, counsel did ask that question. And the reason...
Well, I understand. I've read that 100 times trying to see if I missed something. But it's your responsibility as an appellant to provide a record upon which to, we can decide the issue. So if you know contemporaneous objection is a factor, why was it incumbent upon you as appellant to put on evidence or something to show, no, there was no way. We didn't even find out about this until the jury verdict was rendered.
Because we were cut off by the trial court, and when the issue was begun to be raised at the time, the court couldn't find the rulings and couldn't find...
You could have put that on at the sentencing hearing when they took it up.
I'm sorry, ma'am?
You could have put that on at the sentencing hearing when
No,
they took
it was
up.
not on the record, and I can't recreate a record that doesn't exist. I can't insert facts the way I'd want them to be, as the Commonwealth did when they made that subjective
No, you could have
statement.
called a witness at the sentencing hearing to establish when you were... trial counsel was advised of the jury questions.
The answer is, Judge, it's not in the record.
I know it's not in the record. That's what I'm worried about.
Your Honor, the problem that's not in the record, I think, is cured by the fact that it was not able to be fixed. And the fact that it was raised, the judge then made a decision. The judge had an opportunity to correct it. The correction he could have done was at the end of the evidence, whether or not at the end of the verdict, when it was raised to him, what the judge could have done is said, I'm going to deal with this issue now, or I'm going to deal with this issue later. And what the judge specifically said is, twice said.
Okay, I think I understand your answer. That's fine. Your time has
Yes, ma'am.
expired. Thank you.
Are there any other questions?
No, thank you.